All right, folks, good evening. This is the Monday Night Rule of Law Radio Traffic Show, and this is your host, Eddie Craig. It is August 5th, 2013. We are live tonight. Now, considering something that I went through on Friday with someone who had to go to court, I have a little bit of a subject that I want to talk about tonight, and it's dealing with visiting judges. Now, this was an appearance in a JP court. We disqualified the JP that was in there, who originally presides in that court, because she blatantly threatened the defense with arrest for contempt of court if the defense would not appear before the court the day of trial and enter a plea, thus waiving their right to notice. Because the defendant was never served in accordance with 45.018B, nor were they given any opportunity to object to the substance and form of the complaint and charging instrument because, one, there was no charging instrument, and two, the complaint was not served until the day of trial. So the accused was not going to enter a plea, and the judge threatened her when she wouldn't. Well, rather than rule on the motion when we filed it, the presiding judge went ahead and just recused herself without sending in the motion to the head administrative judge. Well, there's a problem when they do that. First and foremost, there were specific criminal accusations against the judge made in the dereliction of her judicial duties in violation of the law and the rights of the accused that needed to be addressed. Now, those will be followed up on, of course, with judicial conduct complaints, but we wanted a ruling on that motion and those facts by the head administrative judge. But instead of us getting that ruling, she asked a retired judge to sit in her place. Now, the retired judge, when he comes in, has to come in as a visiting judge. He's not active. He's retired in this case. So he comes in as a visiting judge. At that point, he is a justice of the peace. He is no higher an individual than he was or than he is in the court that he's sitting in. He's a retired district judge, but he's not sitting as a district judge. He's sitting as a JP in a JP court. He is required to follow those rules and to abide by them. Yet throughout the entire set of proceedings on Friday, he made it very clear he had no clue what those rules were, and also that it didn't matter. He was going to do what he wanted. We demanded a rehearing of the pretrial motions, which he denied. We also found out that he, as the visiting judge, ruled on the motion to disqualify and denied it. Now, I can't find anything in the statutes whatsoever that allows the visiting judge to rule on the disqualification of the judge he's replacing. Can't find anything that allows that. Now, the other caveat to this is because it is a JP court, you're using a different section of the government code than you are for the municipal court. In the municipal court, you're using 29A, which is an addendum rewrite to Chapter 29, that now gives you specific redress on disqualifying municipal judges. Yet, the legislature didn't see fit to clarify whether or not those same types of proceedings would apply to a JP under the same circumstances. So, for the moment, we're having to go with a different part of the code that absolutely doesn't give you any specific guidelines as to how, when, or what the proper procedure is for disqualifying a justice of the peace when and if they act in violation of the statutes that govern how they're supposed to act in the first place. So we don't have a clear-cut precedent or a clear-cut set of rules for dealing with rogue JP magistrates and judges. But either way, The due process rights that were violated apply across the board. We do have rules for that. Chapter 45 applies equally to justice and municipal courts. And 45.018b is a legislatively granted right. It's granted by the statute as a right, which means the judge has a duty, as does the prosecutor, to be certain the right is not violated. And yet they do it every single time, almost without exception. It's ridiculous that they keep getting away with this. But anyway, this visiting judge keeps saying that, well, the courts have said blah, blah, blah. Judge, I don't care what the courts have said about blah, blah, blah. There's a statute in place that case law does not overrule, because the case law you're citing is for evidence in a district court or this requirement in a district court, and you're sitting in a JP court. But it fell on deaf ears. He ignored it. So here's the little game we're going to play with the visiting judge. I'm willing to bet they didn't do the other things that are required either. For instance, subchapter B of the Government Code, chapter 26, section 26.011, specifically deals with assignment of visiting judge. And it says, if a county judge is absent, incapacitated, or disqualified in a civil or criminal case, the presiding judge shall appoint a visiting judge to hear the case in accordance with subchapter C, chapter 74. Now, county court is not defined in either chapter 74 or here in chapter 26. Or I'm sorry, in chapter 26. It's not defined. But by constitutional mandate, a JP court is a county-level court. It's not a municipal. It's not statutorily created. It's constitutionally created. And it is a county-level court. So when this says a county judge, which one are we actually talking about? A judge of any county-level court? Or are we talking about a judge specifically in a county court? If that's the case, then Chapter 26 could not be applied to visiting judges in district courts either. But I can't find anything that distinguishes between the county judge and a district judge for the purposes of a visiting judge. Now, if I'm wrong, if somebody finds it, let me know. I'm not saying I'm 100% correct, but so far I haven't been able to find it. When you do visiting judge, you only get a certain set of chapters out of the government code, out of any of the codes, in fact. I think there's a total of 5 hits that come back. And this chapter is one of those 5, chapter 26. None of them differentiate that I can see between the county and the district. So, again, if you find it, please let me know. But in the meantime, this is how a visiting judge gets assigned. The presiding judge, that's absent, incapacitated, or disqualified in either a civil or criminal case, can appoint a visiting judge. Well, the presiding judge in this case, the actual JP of the precinct, chose a retired judge to substitute. Well, the retired judge comes in. That immediately places the visiting judge, i.e. the retired judge, under Section 26.015. Again, if this can be applied to JP courts, which it appears to apply to all. Visiting judge to take oath. In addition to any oath previously taken. Previously taken, now, keep that in mind. A person appointed as a visiting judge of a constitutional county court, which a JP court absolutely is, including a person who is a retired, former, or active judge, shall take the oath of office required by the Constitution. Now, here's something else. We know that you can't take the constitutional oath without being required to also take the anti-bribery oath. They are linked because the provisions of the constitutional oath of office specifically mandate and require that that oath cannot be taken until after the anti-bribery oath has been filed. So anytime you see these oaths taken on the same day, there's probably going to be an actual problem, because the oath of office and the anti-bribery were taken simultaneously, and the anti-bribery was not filed prior to the taking of the oath of office, as the language of the Constitution requires. Now, you're going to find judges that argue that it doesn't have to be followed that way. Look, morons, you do not get to rewrite the Constitution because you're a cross-dressing fag. You don't get to do that. Rewriting the language of the Constitution to suit the way your opinion wants it to be is not satisfactory to we the people. We did not give you the power to change the law that we laid down to control your actions. Period. So you are not allowed to reinterpret it in a fashion that would do exactly that. How stupid would we the people actually have to be to limit the power the government has and then say, oh, by the way, you get to interpret the instrument that limits your power so that you can choose to exercise whatever power you want simply by the way you choose to interpret it. That would be catastrophically stupid of we the people. Yet, it is exactly what we are allowing to take place. We need to stop doing that. We really, really do. Now, in addition to taking the oath, you have 26.016 record, and I'm going to cover that on the other side after the break. But this is also very telling, because I will bet you dollars to donuts this that we're about to read also was not done, which means everything the judge did on Friday was absolutely illegal. All right, folks, this is Rule of Law Radio. This is your host, Eddie Craig. We will be back on the other side, so y'all hang on, listen in, and we'll be right back. All right, folks, we are back. This is Rule of Law Radio. Okay, we're going to go a little further down, 26.016, record. When a visiting judge is appointed, the clerk shall enter in the minutes as a part of the proceedings in the cause a record that gives the visiting judge's name and shows that 1, the judge of the court was disqualified, absent, or disabled to try the case, 2, the visiting judge was appointed, and 3, in addition to any oath previously taken, the oath of office prescribed by law for the visiting judge, including a person who is a retired, former, or active judge, was duly administered to the visiting judge. Now, this has to go into the actual court record. Okay? If it's not in there, that judge was never sworn in. If that judge was never sworn in, that judge sat on the bench without any authority behind them whatsoever, thus acted entirely without jurisdiction, thus has no immunity from getting sued. And that will be especially true considering the due process violations that not only the prior judge instituted and this one refused to review as the points of disqualification that got her disqualified in the first place, he then went ahead and perpetrated his own by ignoring the rules that she ignored and proceeding to trial against the accused without any notice, without any due process, without even a notification on the ruling or that the judges had been changed. There was no way for us to disqualify the judge ahead of time because we didn't know the judge had been changed. We didn't know the motion had been ruled on by the same judge. But we still had not been given notice by the prosecution of the complaint or anything else. And yet they keep doing this. Well, question. The case law that I've read says very clearly that lack of notice equates to lack of personal jurisdiction. If you lack personal jurisdiction, Judge, you lack subject matter jurisdiction, because you can't have the personal or the subject matter if you don't have the personal. Okay? You just can't. So any act you do against an individual that's not under your jurisdiction, you're doing without authority. So that means you're acting in your own capacity of your own free will and to your own detriment. And since the case law says that's the way that works, then the case law would essentially have to come to the conclusion that you lack immunity for those acts, because you can't be acting as a judge in your judicial capacity if you don't have subject matter jurisdiction of the issue. The only action you can take and not get held wrongfully accountable is an action of dismissal. Anything else, and you are paddling to a waterfall. But they keep doing it, folks, and we don't keep holding them their feet over the fire when they do it. Now, 26.022, appointment for particular matters. The county judge for good cause may at any time appoint a visiting judge with respect to any pending civil or criminal matter. Okay, and then it goes through the reasons why they can do that. Appointment for absence of judge, 26.023. Appointment to share bench, 024. Compensation of a visiting judge. No administrative powers. A visiting judge under 26.027. A visiting judge appointed under this subchapter does not have the powers of the county judge as a member and presiding officer of the commissioner's court, or the powers of the county judge relating to the general administration of county business. Well, would that then deprive that visiting judge of the magisterial powers since those are considered to be administrative to the court and are not the actions of the county court county business, or possibly even state business? We'd have to see how that would pan out. We'd have to see if there's any case law that's interpreting that. I don't know for sure. But needless to say, I'm willing to bet the things that were required to be done for the judge to even sit weren't done. And if they were, then the judge still acted without jurisdiction because notice was never given as a matter of right to the accused. So, again, no notice, no personal jurisdiction, no subject matter jurisdiction, no immunity. It's a very telling domino effect. Okay, that being said, we have several callers up on the board right now, and I am going to go to Johnny in Texas. Johnny?
Hey, Eddie.
Hey, what you got, man?
Okay, in this case, did you guys put in a challenge to subject matter jurisdiction?
Yeah, in our original special appearance and motion to dismiss.
Okay, and which judge ruled on it, the regular judge or the visiting judge?
The regular judge ruled on the original motions.
Okay, and did you request a hearing on it, or did they just rule in with...
Oh, no, they called us into court, and they didn't actually hold a hearing. They just said, the county attorney said that he doesn't see anything in there of any merit, and the county attorney stood up and said, that's right, Judge, I can't understand any of what's being said in this, blah, blah, blah. It's just a bunch of gobbledygook that doesn't apply in these matters. And the judge said, denied. That was the essential basis of the hearing. When in fact...
They have to give you notice and hearing.
Say again?
See, they have to give you notice and hearing, and that doesn't constitute... You standing there in the courtroom does not constitute a hearing. It doesn't constitute being heard.
No, I agree. But at the same time, the young lady didn't know everything she was going to have to do, and they took complete advantage of that.
Okay, well, you're looking at, how to, like, what to do about it. if you look in, and I think you and I have discussed this before, if you look in Chapter 87 of the Local Government Code, there is a process in there that specifically relates to county officers, and it relates to prosecutors, justice court judges, county judges, clerks, basically any type of county officer. There's a procedure in there where anybody who has lived in Texas for 6 months or more can bring an action in the district court to get a county officer removed from office for incompetence or what is it? Not official misconduct. Actually, yeah, it may be official misconduct. Pull that up real quick and look at those definitions.
You said that was local government code, right? You said that was local government code, right?
Chapter 87 Local Government Code. It's pretty short. And there is a procedure in there where you can bring an action in district court to get a county officer removed from office for incompetence, misfeasance, a few other things.
Yeah, we've gone over this before.
Yeah. I mean, that's what I would be looking at as far, that in addition to the standard stuff. I mean, you look at abuse of official capacity, and official oppression. It's basically if they violate any law related to their office. If a public servant violates any law related to their office, then if you look at the definition of public servant in it's either 1.06 Penal Code or I think it's 1.06. It may be 107. But a public servant is defined as anybody who is performing any function of government. I mean, that's really broad. So, those are the kinds of things that I'd be looking at.
I agree.
So as far, and really, I mean, I know there are issues related to the visiting judge, but it doesn't, in terms of charges on for official oppression, official misconduct, abuse of official capacity, and the procedure that's under Chapter 87 Local Government Code, it doesn't really matter if they're a visiting judge or not. I mean, it's kind of irrelevant,
Yeah, the difference is a retired judge, 87 is not really going to affect them that much, other than it may prevent them from being able to appear as a visiting judge anywhere else. They're not really going to care. They're already on the public dole.
Yeah, well, the criminal charges will still apply to them.
That part's true, as would the lawsuit.
Yep.
All right, folks, we'll be right back on the other side of this break, so y'all hang on.
Okay. All
right, folks, we are back. This is Rule of Law Radio. Okay, I appear to have lost Johnny off the line there. Okay, we're going to go to Rob in Illinois. Rob, what can I do for you?
Hello, Eddie. I have two quick little stories, and I'll make them short, sweet, and to the point.
Okay.
A friend of mine received a citation, and we sent that citation back within 3 days, and we wrote on there that I do not accept this offer to contract, and I do not consent to these proceedings. I can send you the email on that information later. But we sent it back within 3 days, certified mail. He received a letter about a week later from an attorney for the city stating that an administrative hearing has already been scheduled and that they were going to go ahead in his absentia. So I told him not to go down there, and in that meantime, we had sent that attorney the red light camera letter that you had put together, but I modified it so that it would fit his situation. So anyways, he went down there, and the attorney was sitting at the desk, and he walked in and was talking to her, and she's like, well, what happened? And he gave his side of the story. She's like, well, they never told me that. And she said, here's a damage claim form, and she said, you can leave now. So that was the end of that. So that's a little bit of good news. The other one is I had a relative who received a red light camera letter, citation in the mail, and we did the red light camera letter that you have on your website, and we sent the letter in, and he received another letter from the alleged city, whatever this is, that they went ahead and found him. They said, it's right here. It says, it is the finding of the administrative hearing officer that you are liable for the violation alleged in the citation. And they're going to go right ahead, and if the citation's not paid in 30 days, they're going to double it. And it goes on to say, it says, this order constitutes the final administrative order of the hearing officer in accordance with the Illinois Administrative Review Law, blah, blah, blah. An appeal from this order may be filed with the Circuit Court of Cook County within 35 days from the date you receive a copy of this order. So I was wondering what the next course of action would be, since they did not respond to the red light camera letter with that little FOIA request. Also, I want to add in there that these people are hiding behind P.O. boxes, and there's really no names, and the name of the administrative hearing officer that signed this, you can barely make out his name. So I just thought I'd get some comments on you about this.
Well, it's giving you the instructions on filing the appeal with the circuit court, so do that.
Okay. Yeah, they did not answer the FOIA request in that letter.
Well, FOIA does not apply to state agencies.
Okay.
FOIA is federal. There is a state law that will require them to produce public records in your state.
Yeah, that's the one I hit them up with. It's the Illinois Freedom of Information Act, which they are subject to. And they did not respond. Then
what is the punitive action that act allows for, by who, against them, if they don't?
Right. I have to look that up, but I've read some of it, and it says that you have to address your for Illinois, if you're going to use the Illinois Freedom of Information Act request, it must be addressed to the FOIA officer for that city, town, or village. They are the ones who are supposed to, are required and are authorized to respond to them. Really, nobody else is. So these people are really slick when they send out all these little.
Well, but you should be able to call and find out who that is.
Oh, I already know who it is. I already looked it up online.
Okay, so you addressed your request to them?
Yes. So
okay, if you did that, then what does the act for Illinois say can happen if they fail?
Right. Well, we just got the letter a couple days ago, so I'm putting the FOIA request together tonight. So.
Well, I thought you said they never responded to the FOIA you already filed.
They didn't. We were waiting to see how they were going to react to the red light camera letter, and we just received the letter this past over the weekend, and this is how they reacted to it. So it's really a non-reaction. They didn't answer the FOIA request.
Okay.
So we threw the ball back in their court and waited to see what they were going to do.
Okay. Well. They would still have the same problem at the circuit court level they would have had anywhere else. But, of course, you knew an administrative officer is going to always declare you guilty. That's how they get the money.
Right. Yep, that's how they work.
Okay. Now, when you say you're modifying this letter, can you explain that to me a little bit?
Well, with the red light camera letter, for the citation, I left everything intact. I just left the red light camera. For the first citation that we had success on, I just took the red light camera stuff out of there and just left it as is because it wasn't for the red light camera.
Okay.
And then for the red light camera, I left it as is and then just sent it in.
Okay. Except for the names and everything highlighted in yellow, right?
Right.
Okay. Okay. Anything else then, Rob?
No, that's it. I want to thank you for all the good work you're doing, and when you help others, you're really helping yourself. I totally agree with that philosophy.
I'm hoping that's the way it works out before I'm dead.
Right.
All right. Well, thanks for calling in.
Okay. Thank you, Eddie, for everything.
Yes, sir. Bye-bye.
We appreciate it.
I appreciate y'all.
Thanks.
All right. Now we're going to go to Lee in California. Lee, what can we do for you?
Hi, how you doing, Eddie?
So far, so grand.
Okay. I called in last month, July 1st. I guess your thing wasn't on your podcast. You guys didn't put it up.
Okay.
So I guess I got to call back for the information again. And I had 2 infractions and I went to the arraignment. Oh yeah, and before the arraignment, I had filed motions for discovery to the CHP and to the DA, and the DA sent me back a letter saying that I need to file it with the CHP, which I did at both at the same time. So I get to my arraignment, and they're giving, you have to pay in order to go to trial.
Whoa. They make you pay to go to trial?
Right. They want you to pay the bail amount in order for you to have a trial. But at the same time, if you're a student, if you're low income, they make you sign a paper saying that, you will come that day, basically.
Okay, they're making you post bond.
Yes.
Okay.
Now, they said to me if I didn't pay the amount because of the paperwork that I had, the motions, he didn't even give me he didn't even offer me to, if you have, no money, you can sign here and still have your trial. But what he did was give me another arraignment day to come back. And I missed it. But I went back to court the next day, and they gave me an abstract to come back and talk to the judge again. Now, last time I called, you said that for me to file a motion for lack of jurisdiction. I guess under what grounds? I mean, can you give me an idea where to look? I mean,
Well, when you say you have several citations, what are we talking about?
Oh, infractions about for speeding and for double crossing and yellow line.
Okay. Did I not give you the information to talk to Michael or tactical guy Rick out there?
Yeah, I do. But he's kind of hard to get a hold of sometimes, even through his emails.
Yeah. Well, as far as what you're challenging, have you studied any of the statutes on the subject matter at all?
I'm still trying to learn the due process, how to put it together, the due process for the information that I haven't received from them. And I'm still trying to learn, I said, the jurisdiction part.
Okay, well, the jurisdiction part applies to the statutes I'm talking about. If the statutes don't apply to you, then jurisdiction doesn't apply to you. And in California, the statutes, if you go through them, I can't quote them to you off the top of my head, but the statutes make it very clear that the California infractions are commercial. Hang on just a minute, Lee, and we'll get this when we come back. All right, folks, this is Rule of Law Radio. We're about to take a break. This is just before our top of the hour here. Call in number 512-646-1984. Give us a call, give us a holler, give us a question. We will be right back. All right, folks, we are back. This is Rule of Law Radio, and we are talking to Lee in California. All right, Lee, go ahead.
Okay, so I guess you were telling me about the jurisdiction.
Yeah, you need to be reading the statutes dealing with the infractions, because by going through there and finding where it actually states it, which it does, I've seen it. I just don't spend a lot of time dealing with California stuff. I don't have time to learn them for every state of the union, but I know it's there. It specifically says in the definitions and everything else that this applies to commercial activities. It doesn't apply to anything else. And I know both Michael and Rick are dealing in that stuff out there hot and heavy right now with people, and that may be why you're having such a hard time to get in touch with them, because they may have a thing going out there.
Gotcha.
But I would keep trying.
What about, because I didn't enter a plea, and I'm going back to the arraignment again.
Well, everything in the California stuff, at least at the beginning levels, it's all administrative anyway. They won't care if you enter a plea or not. They're just going to do what they're going to do because it's an administrative hearing.
And then if they keep asking me to pay for for my bail, in order for me to have a trial?
Well, again, if they can't move forward without you posting the bond, then why pay it anyway? Just let them sit there. But if they're going to make a ruling against you if you don't post the bond, well, then you have a problem, right?
Correct.
So which way you want to go here? Wait for them to make up a judgment and get what they want, or make them fight for it?
Okay.
Now, look and see if you can do a surety bond versus a cash bond. Here they think that they can make you post a cash bond. They can't. A surety bond is the only thing that Texas law says they can take. They can't take money until a conviction, because if they do, you're being punished before conviction.
Okay. Okay.
All right?
Alrighty. Thank you, Eddie. Appreciate it.
Yes, sir. You have a good day.
You too.
All right. Now, have you ever noticed some people just shouldn't be allowed to breed? I want to tell you something. Think about what happens when you see somebody at Walmart, for instance, looking like some of these people at Walmart posters and pictures on the internet that you'll find. And then imagine that you see an individual that you know is consistently outsmarted by inanimate objects. An example being, you see some person crawling over the top rail of the bin where they put all the big bouncy colored balls for the little kids. You know, the kind where the vertical railing is actually nothing more than a bunch of giant rubber bands that you just reach in and you pull the ball out through the rubber bands. Yet this person is so incapable of recognizing the physical element of what they're dealing with that rather than perform that simplistic function, they crawl right over the top of it. And, of course, the bin breaks and dumps them bodily right into the middle of it on their head. Well, that's the kind of thing I like to watch these municipal and JP court judges do when they don't want to give you your due process rights. Because whether they know it or not, that's exactly the same kind of idiocy they're performing. If you demand it, you document it, and you don't waive it. And then don't ever let it go. Make an issue out of it from the very moment it starts until everything is done. Don't ever quit. But most people don't, because they wind up entering a plea, or they don't argue against the court entering it for them. The appeals court only sees that a plea was entered without any objection by the accused. And next thing you know, all those due process violations you had are washed away because the appeals court mistakenly operates or knowingly operates under the false presumption that you waived your rights altogether by the entering of the plea. So be aware of that. You've got to make this work. All right, now we're going to go to JP in Texas. Is this somebody named JP, or is this a JP I've insulted tonight?
Oh, well, I'm going by JP tonight. My name is John, but I am from Texas.
Well, okay.
But I do have a tyrant down here that I'm dealing with, and you guys started talking about oaths, and that was my originating question. And my question for you was, according to our Constitution here in Texas, all offices shall not exceed 2 years unless otherwise specified. Now, do they have to reaffirm their oath every time they're reelected?
Well, of course they do.
Okay, well, that's what I thought. Well, my tyrant's oath is woefully out of date by 8 years, and it's the wrong form.
Oh, yeah, well, that's not surprising. We had the district judge in Williamson County hadn't had a valid oath of office since 96.
Well, maybe that's why he's kicking me out of his court into a county court about what he did to me last time I went to his court and answered to his false summons, which the first time he arrested me by having me taken outside of the court by his uniformed officers and told me that I was not there and issued an arrest warrant for me for failure to appear. Well, on this appearance, I went in, and a friend of mine, who is another propria persona litigant, went to the restroom. Well, he must have seen that because he called him twice. So I stood up. I asked him if it pleased the court, I would go retrieve him for you. He said, okay. I went up and I went to the restroom to go retrieve this man. I brought him back in the courtroom, and he told me that I can go home. Or no, excuse me. He wasn't in there. I came back in. He said, you can go home. I issued a warrant for your arrest. Well, this has been a wild thing up to this point. I go across the street to the police station to file a criminal complaint. Well, they all just start yelling and screaming at me, and they're familiar with me with the paperwork I've been filing anyway. So realizing I wasn't getting any remedy in there, I went back into the courtroom and told the court I was surrendering to the court because I don't want them coming to my abode to extract me. I know what they're trying to do. Well, he decides that it's not for a failure to appear, that is for disturbing the court. Class B misdemeanor. So
okay.
I don't think he has much interest in the originating cause anymore. I think he's trying to bounce me around and put something else on me that I might not be able to take off. Well, I shouldn't say that.
Okay.
Anyway, I started to call about oaths, but it's something else now.
All right. Well, have you filed judicial conduct complaints against the judge?
Yes, I have filed a motion to disqualify. No, I haven't filed judicial conduct complaints. I did notice the dual office holding secretary or clerk. She gave me my file, but it was missing a few documents, and one of those would be the disqualification of the judge. So that wasn't in there, nor was there a proper response to my Public Information Act request. So I need to go ahead and send that stuff up to the administrative judge, and I'm getting ready to file complaints on all these guys because they're all malfeasant and doing all kinds of crazy stuff down here.
Well, join the club. They're doing it everywhere. And they believe as long as nobody goes after them outside of the court for what they're doing, they will continue to act the way they are and get away with what they're getting away with until they've usurped that authority for so long, we'll never make them surrender it or be able to hold them accountable for it.
Right. Well, you answered my question about the oath, and the judicial conduct thing is in the works. How do I go about dealing with risk management? Do I pursue that road, or do I go elsewhere?
Well, you need to be real careful because filing a claim with risk management is exactly how Rusk falsified felony charges against a gentleman by the name of Robert Fox. Okay? He put in a claim against them for torturing him in jail, and even though that was his provided legal remedy, they turned around and tried to say that everything he put in the document was false, and they were going to arrest and charge him for it. Yet they never presented any evidence that it was false. They just accused him of it and tried to make him, prove everything, rather than them prove that the information he provided was false.
That's the way they like it.
So just be careful.
Yeah, these guys are pretty infamous for that kind of stuff around here anyway.
Well, that's why you don't go without recording or witnesses.
Right. Well, I'm a new listener, but I will let you know how things develop. I've poked the hornet's nest, and they don't really seem too interested in the originating charges. They probably started reading up on transportation code and the paperwork I filed. So they're trying to do something else on me.
Possibly.
I believe so. But anyway, I certainly do enjoy your show, and thank you very much. I do believe that what goes around comes around.
All right. Well, thank you for calling.
All right.
All right. Now we're going to go to Dave in Ohio. Dave, what can we do for you?
Well, Eddie, I'm not sure. I've followed rural law since '05. The wife's in the other room taking notes. I've talked to you and Debbie and Randy several times in the past. Was advised to file EEOC, which we sat through those proceedings and stuff. My labor attorney tells me I got the best case she's ever seen, except I'm missing an element, being able to return to work. And I got to make a filing by December 29th, and she advises going criminal. And they turned my brain to gravy, and I'm having some trouble figuring out exactly what I should do. I don't want to go in there, be pushed around the cop right inside there. I'm up against the deadline, and I'm not sure that I can afford legal help to design the complete complaint for me. I need some direction.
Okay, well, hang on just a second, JP, and I'll see what we can talk about on the other side there, or Dave, and we'll see what we can do on the other side of that, okay?
All right, thanks a lot, Eddie.
Yes, sir. All right, folks, this is Rule of Law Radio. Call-in number 512-646-1984. We got about an hour left in the show, and I need some more callers because after Dave, I've got a couple more, but I will need some more, so y'all give us a call. Anyhow, y'all hang on, and we will be right back. All right, folks, we are back. This is Rule of Law Radio. All right, we're going to finish up with Dave in Ohio. All right, Dave. Now, you were wanting some advice dealing with a civil suit?
Yeah, and no, I need to file a criminal charge so I can open up the civil suit, which I have an attorney who will take it on. But right now it's a labor suit, and I'm missing an element.
Okay, who are you charging with a crime?
Kettering School Board.
Okay, and did you try to file that with your local sheriff?
No, I haven't yet. I was planning doing that Wednesday, and that's why I came with you first. I tried to keep it labor because I got 2 new bosses, and I thought they might take offense if I hit them with criminal points at first. So I tried to do the EEOC route and bargaining with the union and that kind of crap, and it started July 2011. I got 2 new bosses. The first boss wasn't in management. I had a medical disability to have my hours modified. He started harassing me day one. By the time the holidays came and he told me he wasn't going to allow it, I was getting irritated. I called his supervisor, who is in a management position with my medical file. He refused to check him. I got sick, and I notified several people, including the business manager, and asked him to take care of it behind closed doors so there wouldn't be any hard feelings or anything. And 10 weeks went along. The business manager didn't he didn't inform anyone down line, so I was still getting harassed, and I'd already had an email where he agreed to take care of it from him. And then on February 14th, I was off with my nerves in my clothes store that my wife owns, bagging beans, just trying to stay calm. And my new boss barges in the door. I guess someone forgot to lock it, and makes up a story about me waiting on customers, running a register, bagging groceries and stuff. And I go through all these harassment hearings, and it's a known lie. And I just signed away half my business so that, because I'd been in the hospital recently for stomach problems, so that I didn't have so much to do. And they just keep battering me over these lies and calling these meetings, and then against the doctor's advice, 60 days and 30 days before, they changed me from one position to another one, which I was in a building because it was a low-traffic area. They sent me to the main building, which had 3 groups going on all the time, with the doctor telling them it'd be detrimental to me. And by November, them showing up in my room and harassing me and stuff because I was in here with all the people I filed EEOC against, they just turned me to gravy. And she says, actually, I was thinking aggravated assault. That might be a little bit heavy. I don't know if I can get that. But she says she's sure there's numerous torts. My bankruptcy attorney, because 6 months without a paycheck sent me into bankruptcy, said that he would have filed stalking for the guy coming into my store when it was closed. But I think him making up these lies, it's publicly posted. We're not open there. Pastor posted it 3 years ago, and it's never changed. We ain't open on Friday night when he says I was waiting on customers running the store, and I have nothing to do with operations. I've still never done that. But I got to have a criminal charge to somehow to keep my civil labor alive because they're sticking me upstairs on these 97-degree summer days and having 5 people work in air-conditioned buildings in the morning. And the football team practicing downstairs, and I have no ventilation. It's harassing me out of my hours of modification, and I was trying to play along, and they just pushed me to where...
Well, your lawyer may be right. Read the stalking statute in Ohio and see if what the situation is fits the bill. If you can get stalking or some sort of harassment, or if he even touched you in any way when he came into the store, then you can get some sort of simple assault, then you'll have what you need. Most states won't allow you to charge him with trespass unless he was ordered to leave and returned after he had been instructed not to. So trespass probably won't fly, but one of the others might.
Yeah. Well, I got to have something to keep my case open. I don't think.
Well, you need to look through those in the penal code there in Ohio. You need to look through those options there in penal code for Ohio and find out what they are. I mean, if you're asking me to tell you, I don't know. I don't know what your penal code in Ohio is.
I thought you might have a good guess of the best way.
Well, I agree with what your attorney is saying.
Some type of assault or...
Well, again, you need to read what the elements of each of those that we've mentioned are and see if the actions of this individual match up with any of those. That's the only way you're going to be able to bring the charge is to say, okay, it says that he has to do A, he has to do B, he has to do C. Can I show he did all of those? Yes, I can. Then there's the charge.
Okay. Yeah, and there's no hope a prosecutor help me walk through charges, are they?
No.
No.
You can go to the prosecutor's office and say, I need to file a charge, but you need to make sure that the one you go in there to file is one that they can prove.
Yeah.
That's why you need to look at them first.
Before I walk through the door. And yeah, when I walk through the door, I need to have the charge and have the
Correct.
charge ready. I can't wait.
Correct.
Yeah, and I have a logbook sitting here. It's just that they kind of shattered me to where making long, intense reading kind of hard at the moment, Eddie. I appreciate it.
Yes, sir. And it shouldn't be that long or that intense. Most penal code statutes are fairly simplistic and short.
Well, yeah, I love to listen to your show every night at work, and I've not been able to listen for 9 months. They did something to my nervous system. Getting into it sets me off to work.
Yeah, I can understand. I don't mix well with a lot of nervous systems.
Yeah. Thanks a lot, Eddie.
All right. Thanks for calling in, Dave. All right. Now we're going to go to Michael in Texas. Michael, what can we do for you?
Hi. Am I coming in clear enough?
So far.
Okay, good. First of all, sorry I missed your traffic seminar this weekend because I started to head down to Austin from.
Actually, we didn't have one this weekend. I'm still in a holding pattern for my. Passport, so we didn't have one this weekend either.
Yeah. I found that out about 45 minutes on the way down. It was a spur of a moment thing I wanted to go, and then it suddenly occurred to me. I was like, I wonder if he's not having it today. So anyway, I was glad I didn't go all the way. And but do you know when you're likely? You just don't know until the passport thing gets resolved, right?
That's correct.
You're gonna have another. Okay. So now I was recently delighted to see the InfoWars video. I think it's like an hour and a half, 2 hours or something.
2.5 hours.
2.5 hours, yeah. But the government doesn't want you to know, and so that was inspiring. Was that done about a month and a half, 2 months ago?
It was done April 11th.
Oh, April 11th. Okay, good. Having attended just the one traffic seminar down in Austin a couple months back, it seems like it's a very close overlap, condensed version, but obviously only does.
Yeah, that's exactly what it is. I had to do the whole thing on the fly, top to bottom, didn't take any breaks, didn't stop for anything other than just a couple of slide corrections and just some commentary to make sure that they understood what was going on. But for the most part, yeah, we were there maybe three hours, 15 minutes or so. And when they edited it all down, it came out to the 2.5 hours.
Sure. Now, I have kind of a pragmatic question, and I'm ashamed to even ask this because I know I'm going to probably, to some extent, not surprise you, but let you down because I've really wanted for a long time to fight this good fight. But now that I'm in Texas and in light of the fact that I definitely want to keep, my job, I'm thinking that I may or may very well not be able to wing it to be prepared to go the route of not having a driver's license and not having tags on my car. But I still would like to implement the principles and be involved in any and every way I possibly can. Certainly, when it comes to traffic stops, having at least somewhat of a backbone to challenge, am I under arrest or am I free to go? These sorts of things. But I was wondering if you had any advice for somebody like me who just isn't quite there yet, and am I completely lost for the foreseeable future if I, do get a driver's license, no matter what I put in the signature line, or can I yet redeem myself down the road if I feel comfortable down the road with, moving forward?
Everything starts at the stop. The rights you waive at the stop, you do not ever get back.
Right. Okay. Yeah. I liked what you said in the video, by the way, about the fact that you should only be doing 3 things every time you speak. I cannot repeat them, but I know they all had to do with asserting rights or with...
invoking a right, demanding a right, protecting a right.
That's good. And if you're not doing that, shut up, keep shutting up, and when you're done, shut up some more.
That's it.
So the reason for my call had to do with Ian Freeman. Do you have any time to talk about the Ian Freeman court case about a week or so ago?
I don't know anything about it.
Not a thing about it. But what's interesting about it is that for the first 40 or 50 minutes, Mark Stevens was on, he wasn't acting as his attorney. What do you call it, a counselor or whatever the term is?
Yeah.
Yeah. And eventually the administrative judge, who was the chief judge, by the way, who was challenged to recuse himself and wouldn't, but he eventually cut Mark off, which probably doesn't surprise you. I don't know how much you know about Mark, but eventually he pushes enough buttons. That's what happens. But I believe what happened. I didn't see the whole video after that, but I believe what happened after that was that Ian Freeman basically launched forth into arguing some, if not a lot, of the types of arguments that you do about commerce and being in commerce, not being in commerce. I doubt that he necessarily knew the codes and the statutes and argued them the way that you would have, certainly, as far as your script. But that's why I thought I would bring it up, because I don't know to what extent he's studied at your feet, so to speak, in the sense of being familiar with your
Yeah, I don't know that either. I don't recognize the gentleman by name, so I can't really answer that.
Yeah, he's out of New Hampshire. He's part of
yeah, I mean, I know him. I know him from the videos. He's got videos on YouTube.
Yeah,
but I don't know him personally, and I don't know. I know he does a lot of the Canada free man stuff and the straw man stuff and things like that, or at least was, and that stuff that I don't do.
Right.
But I don't know if he's changed tactics recently or anything of that sort.
Well, I've listened to him about as long as I've listened to you and Debbie and Randy, which is probably about 3 or 4 years. And I must confess, I haven't heard him say too much along those lines. If he believes in that kind of thing, I don't think he really stands forcefully behind it. Well, I hear the music. So.
Okay, yeah, if you want to hang on just a second, Michael, we're going to take a break. We'll be right back.
Thank you.
All right, folks, this is Rule of Law Radio. Calling number 512-646-1984. Mary, Matt, I see y'all there. Y'all hang on. We will be right back after this to take your calls. All right, folks, this is Rule of Law Radio. Your host, Eddie Craig. We will be right back, so y'all hang on. All right, folks, we are back. We're going to finish up with Michael in Texas. All right, Michael.
All right, so just 2 more things, I guess.
Okay.
One is that for those who... Can you hear me?
Yeah.
Okay. So 2 things. One is that for those who are interested to watch it, because I do encourage you to watch, it's pretty amazing stuff, actually, the Ian Freeman hearing. It is on YouTube. I believe it was posted within the last week or 2 weeks, and I don't know how to suggest you search for it other than Ian Freeman and time search it for the last couple of weeks. And it's about an hour and a half or so. And the interesting thing about it, though, that is the second point to make, is I think the one thing that Mark Stevens did particularly well that I didn't see coming, and I thought it was really powerful stuff, was he caught and mentioned to the administrative law judge that by allowing the proceedings to move forward without the prosecutor presenting evidence that the laws and the codes apply to Ian, that the judge was taking up the prosecutor's burden, and that therefore he showed himself to be biased. And personally, the more he kept driving that point home, the more it started to make sense. And I got the sense that the judge, patient as he was, and he was really pretty patient, that he was starting to kind of realize that his goose was cooked to an extent. So anyway, I did think it was very powerful stuff in many, many respects. And I hope that we can all learn from these type of techniques. We don't always have to do it the same way. I totally respect what you're doing and what he's doing, and I know that you don't always have the same approaches. So I don't know. I'm just learning every time I listen or watch. I'm impressed and I'm inspired. So thanks for all you're doing. And again, if you want to go out and check that out, it's out there on YouTube. It's good video to watch, and I'm looking forward to going back to your video and to the downloads I've received from you on the scripts for the side of the road conversation with the policeman and the courtroom conversation with with the prosecutor and or policeman.
Okay. Well, thanks for calling in, Michael. Appreciate it.
Thank you so much. Yes, sir. Yes, sir. Bye-bye.
Bye-bye. All right. Now we're going to go to Mary in Texas. Mary, what can we do for you?
Hey, Eddie. Thanks for having me on.
You're so welcome.
I was a little upset yesterday. I guess it was a routine ticket I got for failure to yield at a stop sign off I-35. I talked to you about it a little earlier today. I keep a type of dash cam on my car at all times. It's just an extra cell phone that I bought over at Cricket Wireless, and I keep on my dash. And I noticed twice during their visit, or when they had arrested or detained me, that the camera had gone off. And then when they left the car, they had asked me, if I was recording them, and I said, no, I wasn't recording them. I just record my traveling. And they asked me why, and I said, for insurance purposes. They're courteous, gave me a ticket for failure to stop. And I told them I might be seeing them in court. But the camera's since been broken. I've used it for 2 months, and all of the video and audio has been erased from it, and it won't record. I talked with an electrical engineer friend of ours, and he believes, like I do, that the police somehow were involved with the erasing or tampering with the video camera. So I don't know. I'm not a technical person. I just know that it happened, and the camera broke. All of my video was erased during the detainment.
Well, did they ever touch the phone?
No, they didn't. But they knew it was recording, and you say they can read those license plate stuff now with those little codes that we have at the bottom of our license plate and all this stuff. And I don't know. I'm a little concerned that if they might have equipment, I've heard that through Electronic Frontier Foundation, that each cop car has a lot of radio type of cell phone equipment in there that they can actually download a lot of information. So I just want to put it out there. I've had my emails hacked before when I was in a judicial conduct complaint. I wrote one when the judge had threatened to shove a plea down one of our friends' throat, and my emails got hacked at that point. So I'm just a little concerned about maybe they have the technology that they can do this and possibly destroy evidence.
Well, it's possible.
Maybe
I mean, it's possible they may have done something, but I'm racking my brain trying to figure out what it could be, because it can't be, if it was an EMP device that did it, then nothing would work. Anything electronic anywhere within the zone of that would be dead, including their car. So it wasn't an EMP method.
Well, I just want to throw it out there. I mean, it may not have anything to do with them, but apparently it broke during that detainment, and I just wanted to throw it out there.
Okay.
if anyone has anything to say about that.
All right. Well, I appreciate it, Mary. Thanks for the news.
Okay.
All right. You have a safe evening.
Okay.
Bye-bye. All right. Now we're going to go to Matt in Ohio, who is my last caller. I need some more because I'm going to have another half hour to fill here, folks. All right, Matt, what can we do for you?
Hi, Eddie. Thanks for taking my call.
Sure.
I had spoken with you maybe about a month and a half ago. I had received a letter in the mail alleging that I had violated a red light camera, not statute, but regulation, I guess, in California. I'm in Ohio, so I downloaded and submitted your special appearance letter with a couple minor modifications with the date, and to the county and to the city traffic enforcement program. The Superior Court of California sent me a notice of bail, and the City of Millbrae automated photo enforcement program. They had included the pictures and the signature of the apparently the swearing officers.
And what are these pictures of?
The pictures are of a vehicle.
Of a what?
Well, a car. What they allege to be a vehicle, but which is not under the definitions. A car, essentially, one picture of the car coming up to a red light, and then the next picture of the car, turning at the red light, turning right on the red light.
Does it show any identifying information of the person inside?
It does have a fuzzy picture of the driver, of the person traveling at the driver's side. I don't know what of a person in the vehicle, in the car. Yes.
Okay. But can they identify them from this fuzzy picture?
Possibly. I wouldn't say so specifically, but I possibly, yeah.
Okay.
Now, in response to the special appearance letter, the City of Millbrae, the Automated Photo Enforcement Group, sent back documents related to the open records requests in there, at least two of the four items. The four items being evidence the prosecution may have in their possession, regardless of their intent to make or use of such evidence, proving my direct or knowing involvement or participation in this alleged crime, and in all maintenance records for the camera involved. They included those two items. They claimed that 3 and 4 training certification records relating to the installation, use, maintenance, and interpretation, programming, and computational algorithms for these cameras, and the training certification algorithms for the cameras relating to the in-state officer that will presumably testify. They claim that those are not applicable. I don't know if they were claiming maybe just in terms of them, they weren't applicable.
Okay, what does their Open Records Act require in California? Does their Open Records Act require that they give a written response as to why they're not providing something?
That I don't know. I'd have to look that up.
You need to find out, because not applicable is a legal determination, and that's something they can't make. A judge is the only one that could make a legal determination. If you requested the information, they have one of two choices. They normally, under an information request, the choice is provide it as requested, or don't provide it, but you must give the reason why. And not applicable is a determination, not a reason. They have to specifically state that it's either exempted under the information request, it's excluded specifically by the statutes governing the information request, or they're inapplicable because we don't think they belong here, and then they're screwed because that's the legal determination. Okay, hang on just a second, Matt. We'll get this on the other side. Folks, Rule of Law Radio, 512-646-1984. We'll be right back.
Your body,
All right, folks, we are back. This is Rule of Law Radio. We're talking to Matt in Ohio. Okay, Matt.
Okay, thanks, Eddie. So let's see. So I'll look up the open records request. Now, how would I challenge that if, for instance, like you say, they didn't comply, they didn't give a reason, if indeed they are required by statute to do so? How would you go about challenging that if this were you?
Well, again, it depends on what the statute says they're supposed to do. That's what you need to know. If they, like, for instance, here in Texas, if they're going to deny your request, they're required to get a verification from the state attorney general's office that the denial is proper. They can't just do it themselves. They have to seek a determination by the attorney general's office, determining from the attorney general's office whether or not that information is required to be turned over under the act.
Right. And so if you got something like this in Texas and they didn't comply with that, how would you challenge it?
I would file a criminal complaint, which is also a part of the act, that says if they don't do what they're required to do, you file a criminal complaint with the attorney general against them.
Okay. So that's what Texas requires. So basically, I'll have to look into the statutes in California to see what the penalty is for not complying with the open records.
Correct.
Okay.
What the penalty is and what method they're required to follow if they're going to deny any response or any part thereof.
Okay. Now, is there a way to... Now, so my next question becomes, what would be the next step? So if I filed a criminal complaint, if it's appropriate, what would be the next step in challenging this proceeding? I did get I sent the same special appearance letter to the Superior Court that sent the bail notice. They did not reply with any records requests themselves. The only reply that they sent was from the court executive officer, clerk and jury commissioner, a notice saying the commissioner has denied your request. The fine is such and such and is due in a couple of weeks.
What request?
The special appearance letter is the only thing that I sent them, so it doesn't identify what the request is that they're denying. It's a form letter that says the commissioner has denied your request, and he checked out this form letter. It doesn't deny what the request. It doesn't identify what the request is.
Yeah, but what did you request from them? Anything?
Well, just certainly the open records demands that are in the special appearance letter. If it is the government's decision to move forward in this matter, then this letter is to be considered and construed as an open records public information FOIA request under all appropriate laws for copies of the following documents, records, and related information.
Okay, again, if they're denying a request made under open records or FOIA, that's why you need to know what the procedure is. If they're denying it and can't give you a reason why, and that's information you're entitled to, and they didn't get a determination they're supposed to make from somebody higher than them, they've got a problem, and you need to make sure they get it.
Okay, good. All right, so I'll look up those statutes. Now, what would be the next step in either stopping? They say that the fine is now due, so I have to challenge. I assume I have to file something to challenge the fine or to suspend this proceedings, before the due date.
What was the procedure? Again, if they've already ruled against you in the administrative side, then they had to give you notice of what the appeal side is.
I'm not sure what you mean, what the appeal side is.
Yeah, what's the process for appeal if they ruled against you administratively? If they ruled against you administratively with no opportunity to appeal an administrative decision, buddy, that's a bill of attainder. That's unconstitutional and unlawful in every state.
Yeah, there's nothing, certainly in this Superior Court letter with the checked off denied request, there is nothing about an appeal.
Okay, where's the court of original hearing?
The Superior Court of California, County of San Mateo.
Okay, and again, what are they treating this process as? Are they treating it as civil? Are they treating it as administrative, criminal? How are they treating it?
You know what? It doesn't identify that, to my understanding. Or let's put it this way. There's a violation, identifies VC 21453A, red signal vehicular responsibility, maybe.
Well, that'll be the vehicle code.
Right. And so it depends on what that would fall under in the state of California with respect to the vehicle codes, whether it's administrative or criminal. That's another thing I'd have to look up.
Right.
So I guess the way to proceed depends on whether it's administrative or criminal, I assume.
That is correct. What they're allowed to do as far as proceeding is governed by the same thing. They cannot convict you in a criminal case absentia.
Right.
Okay? The only time they can do that is if you were initially present when the trial began and then you disappeared. They can continue then, but they cannot conduct a criminal trial in your absence.
Right. Now how would you, so they've denied the request. How do you...
Again, you need to look and see what the records request said they have to do to comply. Without knowing that, I can't answer the question I believe you're asking.
Yeah. Okay. Is that the only way to challenge at this point, or is that just the first?
You're not challenging the ticket on this. You're challenging the fact that they didn't give you information they were required to give you, or were allowed to exempt, but had to exempt in a certain way under certain conditions. That's separate issue from the charge itself.
Right. Yeah, I wasn't referring to the challenging the charge. I was referring to challenging the proceeding, because there has to be some.
Well, in an administrative proceeding, they can do whatever the heck they want. We objected to the administrative proceeding via the letter.
Right. Right. But at the same time, I'm going to have to. I assume if they try to, for instance, collect on the fine that they claim is due, I will have to,
you need to put in whatever the requirement is for the appeal. They can't collect as long as the process is ongoing, and it's ongoing as long as it's on appeal.
Okay, I see. And that would be an appeal of whatever this is administrative or criminal?
Correct. And there should be instructions on how to make the appeal.
Okay, that's interesting. None of the documentation they provided me has instructions on how to do that.
Right. And if that's the case, then they're denying you in your appeal. Thus, this becomes a bill of attainder real quick.
Now, where do you present that, challenge? The fact that it's a bill of attainder, where do you go with that?
You would have to sue them to make that.
Okay, what court would you sue them in?
You'd have to sue. Well, you could sue them in federal court at that point, since you live in a different state and they're they're acting in a prohibited manner that affects a protected right at the federal level.
Right. Now, do you know offhand if I would have to sue in a federal court in California, or could I sue, for instance?
You could sue in any federal court, in either there or where you are. If you're suing, you can choose the venue as far as the federal court goes, because they're harming you where you live in that case. Your rights are where you are.
Right, and that's a good point, because they have told me that they can, they claim the right to garnish wages, intercept a tax refund, so on. Or attach wages, I should say. So that certainly goes to, my property where I'm located. Do you think, is this Okay, so I've got to go to the statutes in California. If this is administrative, then if this turns out to be administrative, do I just go ahead right away and file in federal court?
No, you need to do the appeals process, whatever it is. If there isn't one, then you immediately file in federal court.
Okay, what if it's criminal? If it turns out to be criminal under California?
Well, then they convicted you in absentia, and they have a different problem.
And do I file that?
Matt, I'm going to break. Hang on. All right, folks, we'll be right back. Y'all hang on. All right, folks, we are back. This is Rule of Law Radio. Okay, Matt, I need to wrap this up. I've got another couple of callers on the board I need to get to.
All right.
Okay, so you really got it. You really have to check out those statutes as to what information they're required to do. Get the appeal. If there's nothing in the paperwork they sent you, call and get it. Find out who you have to appeal to and by what date.
Gotcha. Okay, very good. All right. If you don't mind, I'll give you a call next week after I do a little bit of digging and see if you have any thoughts based on what I find then.
Okay.
Very good. Thanks a lot for your help, Eddie.
Yes, sir. You have a good night. All right. Now we're going to go to Ruby in Texas. Ruby, what can we do for you?
Hi, Eddie. Can you hear me?
Yes.
Okay, good, because the phone hung up accidentally. Got a appearance notice for offense failure to obtain access animal permit for dogs. And it says that I'm hereby required to appear in the San Antonio Municipal Court. And it says all cases in court are heard in assigned scheduled times. You must appear at the time of the case scheduled, and if you fail to appear as instructed, a warrant for your arrest will be issued. And then it also says that if I wish to plead guilty and resolve my case without a court appearance, I may visit their WW online for options, to give them money, I guess. And
have they served you with a criminal complaint yet?
This it was in the mail. Not hand like by I guess a sheriff or something serving me.
Is that a yes or no?
They're serving me through the mail. You know, it says right on the outside of it, return service request, but I never.
No, signed it. Have you looked at what's in it?
No, it doesn't say. It's just a piece of paper that you tear the sides off of it and then you open it up and there it is, just a letter.
Okay. Well, we need to see what that is. They're required to serve you with a copy of the complaint. You know this, 45.018B. If they haven't done that, then you need to be filing the special appearance and motion to dismiss. Lack of notice.
Okay.
Now, you're also going to file the motion to quash the illegal summons, which is what this letter actually is. It's an illegal summons.
Mm-hmm.
And you're going to file the formal declination to plea.
Okay.
Those will be the primaries you're going to be filing in this case.
Okay.
We're also, since this is prosecuted in municipal court, this will have to be under a municipal ordinance. You're going to file the motion to dismiss or to contest the prosecuting attorney who cannot prosecute in the name of the state because he's a city attorney. And what else? Yeah. You're also going to be asking for a dismissal for lack of jurisdiction because you're not one of the entities to which an ordinance applies.
Okay. And when I do that, do I need to give them the statute and case law on that, or do
everything should already be in the motion? If you have the seminar material, these are already written for you. If you don't have the seminar material, well, then yeah, you're going to have to kind of write them from scratch. But that's not too hard. I mean, you can always look in cases where people have already filed the stuff that I've got and get samples of them there, but you'd have to re-edit them to suit your condition, which would take you longer.
Mm-hmm. Okay. Well, that sounds good, and I can always email and
yes.
Yeah, that's good. Okay, well, that's why I was calling. Thanks, Eddie. You sure helped me a lot. Thanks a lot.
You are welcome.
Okay, bye-bye. Have a good night.
You too. Thanks for calling in.
Okay, bye-bye.
All right, now we're going to go to Rob in Illinois. Rob, what can we do for you?
Hello, Eddie. I was on at the beginning of the call, and I just had to call back in one more time.
Yeah, I was noticing that.
I'm one of your biggest fans out here. I'm telling everybody about you. I have, if you want, I'll send you an email for that guy Matt, and he can contact me if he wants. I got a little bit of information to send his way on that situation. Don't quote me on this, but I have a friend out there in California who knows a little bit about this stuff, and I think he said to do a writ of mandamus for judicial review to force them to show you the contract. That's for the other side to show you what contract you were under, and that's
well. They would have to do that in this lady's case because it's an ordinance, and the ordinance can only be applicable to the city employees or its contractors. It can't be applicable to anything else because ordinance is a corporate rule. Therefore, you have to be a corporate relationship in order for that rule to be applicable.
Right. Oh, I hear you on that one. That's absolutely right, and that's what I put into that letter to them for that citation. I added this in there as far as one of the Freedom of Information Act requests, proving that I knowingly, willingly, and intentionally volunteered into a contract with the city of Joe Blow with consideration and full disclosure that compels me to a duty to perform. And I also added in, because I heard this on your call a couple weeks ago about some guy asking for their tax identification number. So I asked them for that in the FOIA request, that any and all evidence of whatever nature or type the prosecution may have in their possession, the city of Joe Blow tax identification number, and the tax identification number for the alleged administrative court regarding this matter. So I thought I'd throw the whole kitchen sink in there while I was at it.
Yeah. Do what works.
Right, because if you're not under contract with these people, you're not subject to them. If you're not one of the employees or you're not under contract, I want to make that specifically clear. You're not subject.
Be careful on how you generalize that. In relation to a municipality, the statement is accurate. In relation to, say, a penal code violation and stuff, that is not necessarily true. Most offenses in penal codes are based upon the common law predecessing crime. They don't need a contract with you to hold you accountable under a common law offense.
That's absolutely correct. I'm glad you clarified that for everybody out there.
So, yeah, just make real careful about making generalized statements. Be specific, because people will take it at face value, unfortunately, too often without double-checking what they're hearing, and it will get someone in deep trouble.
Oh, yeah, I hear you. Definitely. Everybody out there listening, Eddie's the man.
I wouldn't go that far, though I am one. Don't get me wrong there, but I wouldn't go far that I'm the man.
Yes. I've learned a lot from you in the past year that I've been listening.
Well, I'm glad I'm useful somehow or other.
Yeah. That's great. We're glad.
See, all you detractors in high school, you're wrong. I did turn out useful somewhere.
Yes. We love you out here.
Well, I appreciate it. Let's see how many more we can get. By the way, folks, if you haven't yet done so, if you are on Facebook, go to Tao Law, T-A-O space L-A-W. Send me a friend request. Go to my like page of Tao of Law. That's keeping the information up on when we're expecting to have things done for the website so that we can actually get this off the ground and get membership going and get the online classes rolling. Remember, it takes a lot of us to make this work for one simple reason. Only by working together are we going to change what our legislature's doing by becoming the legislature, by overwhelming them to the point where we control, not them as individuals. We control our lives by telling them to keep out of it and making sure that we only put people up there that understand that and will hold that true. The other way is that allows us to organize and put mass effort into making the changes that need to be changed, whatever that effort turns out to be. It'll let us organize, collaborate, and meet and greet each other in a whole new way with a whole new direction. And hopefully we can get the tools and everything set up where that will become a reality for us all, because we are going to need it and need it soon. Okay, Rob, you got anything else?
No, that's about it. I'm sure I'll think of something after I hang up, but that's good enough for tonight. But thanks, Eddie, for everything you do.
All right, Rob, thank you, and I appreciate you calling in.
Right, thank you.
Yes, sir.
Okay.
All right, I got just a little under 3 minutes left. I don't have any other callers, so I'm just going to try to run this out by keeping up with the information. We don't still have a specific date when we're going to have the online portion of Tower of Law ready to go, but we are working steadily on getting it ready to go. So y'all please hang in there, be patient. I'm going to pull a Blizzard Entertainment thing here, and I'm going to say we will launch when it's ready to launch. Because for the parts that we have, we want them to work well. And we will be bringing everything up in phases and stages so that it does all work and play well together and with all the users when we get it going. So please keep that in mind, that we're not trying to put it off or slow it down. We want it to be right. And we've got to make sure, for many, many reasons, that it's also as secure and unhackable as possible, not to mention stable. And no, we will not knowingly integrate any NSA or Microsoft backdoors into anything. So we will try to keep this as secure and safe as possible. The system we're using also will not be tracking any user information other than just, your name, your login. And then the way we're going to implement the login means we probably won't even have to be storing passwords. We're going to be storing encryption keys, basically, or hashes to compare, not the actual passwords if we're doing it somewhat white. But me and the programmer will get on that. The other programmer will get on that and see what we can hammer out and make sure that all works. But in any case, this is something we can use. It will be a very useful tool, and we really need to get as many people on board as possible. I've cleared 1,000 Facebook friends up there that want to be involved in it. We need to get a lot more than that, okay? It's a good start, but let's work together by being together on this system and making it useful for everyone. Folks, this has been the Monday Night Rule of Law Radio Traffic Show. I am your host, Eddie Craig. I want to thank you all for your calls, for listening, for your emails, your questions. Let's work together. Let's make the world the way it needs to be. Free. Y'all have a good night, and God bless you all.